I'm challenging the setting aside of the,
What is wrong?
my lord, I'll just, I have made a list of dates, my lord. It will be important, my lord.
What is the date of suspension?
Date of suspension, my lord, is 2/6/2024 with effect from 14/5/2024.
Where is the order?
My lord will find the suspension order at the writ petition at page 44. 2nd June 2024.
Okay, this is deemed suspension
Deemed
due
suspension.
to his arrest.
Yes.
Now, where is the provision?
My lord will kindly see at page 40, the prayer also is for setting aside this suspension, the initial suspension.
Yes, it has a survival period,
Yes, my lord.
currency period.
Yes.
So definitely it is a continuing one. Where is the provision?
Then, my lord,
Yes.
yes, my lord. Rule 10, Rule 7, my lord.
Yes.
Rule
I
10,
think it is reflected in the judgment.
yes, my lord. The prayer is for setting aside the initial suspension, my lord. What has been set aside is the extended suspension, my lord.
The suspension order in case of deemed suspension, it is governed by the proviso to Rule 7, Sub-Rule 7 of Rule 10.
Yes, my lord.
Let us read it, page 16.
Page?
16 of the memo of appeal.
Yes, my lord. My lord, to my respectful submission, both the learned single bench, they have relied only on Rule 10.7. They have not seen Rule 10.6. What Rule
Let us see the
10.6?
Rule 26. CCS rules.
CCS. What the Rule 6 say, emphasizes, it says about review to be done within 90 days. And thereafter,
Shall be made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revise the rule before the exposure of
what is the requirement is the review to be done. And then pass order, my lord.
Two conditions.
Two conditions, my lord.
Review to be done
Yes, my lord.
within 90 days and pass orders.
Yes, my lord. Pass orders, my lord. My lord.
Either extending or revoking.
Yes.
Here it is a case of extension.
Yes. The review has been done.
Subsequent review shall be made before expiry of the extended period of suspension.
Yes, my lord.
Extended
Subsequent
shall not
reviews
be period
also.
for so and so days.
Reviews also. It
Pass orders. And pass orders.
yes, my lord. Pass orders is
Two.
my lord.
What is passing order?
Yes, my lord. Passing order, my lord, the passing of order after whatever the review has been done, that can be done. What is the requirement to my respectful submission is the review has to be done within the 90 days. Decision has to be taken. That decision later on can be.
That will have no force.
No, my lord. Here, the decision was already
What
taken.
is order?
Yes, my lord. Review has to be done.
Review has to be done and to pass orders. There is an end.
My lord,
What is the meaning of passing order? In the name of the governor.
Yes, my lord. Here,
by Article 162 of the Constitution.
Yes, my lord.
It has no value at all.
No, my lord. The order will be followed after the review, my lord. That order has followed, my lord. The order which has been set aside has followed.
Let us see the proviso also.
Yes. Rule 7, my lord, this Rule 7 has been amended, my lord, in 2022, my lord. Sub-Rule 7 has been amended.
What is reflected in the judgment is not proper, correct?
No, no, my lord.
Not correct.
No, no, my lord. That what has been reflected, my lord.
Okay.
Yes, my lord.
Okay. Which provision governs deemed suspension?
Deemed suspension Rule 10(2), Sub-Rule 2.
Deemed to prison with effect from the date of his detention, if he is detained in custody. What is the date of deemed suspension here?
Deemed suspension is 14/5/2024. 14/5/2024.
No.
With
Deemed
effect from-
suspension is with effect from
14/5/2024.
2025.
4.
There is a second proviso. Otherwise, it is same. First proviso is same.
Yes, ma'am.
So as part of this proviso, first proviso, it is will count from the date of government servant detained in custody is released from detention, or the date on which the fact of his release from detention is intimated to his appointing authority, whichever is later.
Later.
Now, you say it is 4/3/2025.
4/3/2025. was
It has
the
been
date.
intimated. So
Intimated.
this is to be the date should start from this,
Yes.
right?
Yes.
And 90 days.
90 days.
Now, where is the 90 days?
The 90 days
90 days will expire
on 2/6/2025.
2/6/2025. Where is the extension order?
3/6/2025 with effect from 2/6/2025. And
Where
my
have
lord,
you stated that the review committee was held on?
my lord,
Where is the order? Where is
order, my lord, at page 59 in our affidavit, page 59, para 6. Para 6, my lord. On receipt of
Where is the notification 28/5/2025?
notification, that is by which it was constituted and the review committee,
Copy of the order. Where is that notification?
my lord, that we did not annex. It was not required. Only the extension was annexed.
I'm
That
not
I have-
satisfied
Yes, my
to that effect. Joined. He is not joined.
No, my lord.
I'm not fully convinced, but status quo, he has not joined.
Yes, no, not joined.
He has not joined.
Malad, I lordship permission, Malad, may I make a small submission, Malad? Since Malad, of course, Malad, I have not filed my Malad the
Who are you? You are for the petitioner.
Petitioner, Malad.
Ah.
Now responded, Malad. I'm the Malad the respondent.
Okay, you appeared and bring the proceedings of the review committee.
Malad.
We fix a date.
Yes, Malad.
In fact, my lord, this order which has been set aside, that was not even challenged.
Not required.
Not
It's the
required, ma'am.
currency of the suspension
ma'am.
period.
No, my lord, they had challenged only the initial.
Initial, because it was
But-
continuing.
Yes, my lord, if
He
they,
was under the impression that it is continuing beyond period. Now, ultimately, it has been brought to notice.
yes,
Whether that has validity or not,
that has,
that order has a validity or not. The Reliance Single just said that it is beyond 91 days, so it is not required to be
my
selected.
lord, after the filing of the writ petition, the extension was done.
Right?
The
Then
extension,
Reliance Single just found that this is beyond period. So non-Estin law,
in fact,
since he has not joined, we will put a status quo
Yes.
as on today,
Malad,
but we'll put it, since he has appeared, we put it on next.
Malad, instead of that, Malad, lordship may kindly issue notice, Malad. I'll come to that, Malad, the reply, Malad. Come with that reply, Malad. Malad, instead of Malad passing, Malad, status quo, Malad. Malad, what happened in Malad, after my release from the custody, Malad, I intimated to the authorities on, Malad, they've taken the wrong note on the Malad date when I intimated to the Malad authorities, Malad. After my release, I intimated to the Malad authorities on 21st January 2025, Malad. And they have duly acknowledged, Malad. After
Where is that letter?
Malad, it is in my read petition, Malad. I have enclosed that has been duly acknowledged by the undersecretary. Thereafter, several communication. Malad, of late, Malad, this impugn order, extension order has been issued after filing of this read petition, Malad. Malad, if lordship peruse my Malad, I have not gone through the Malad.
Okay, Mr. You get the records?
Malad, it is page number 51, Malad. Malad,
I've seen.
page 51.
51,
What
Malad.
is you?
This is the intimation letter.
When you were released?
On 18, Malad, 18 January, Malad,
Okay.
18 January, I was released. On 21 January itself, Malad, I intimated to the authorities concerned that I am released. So therefore, my case may be considered, Malad.
No, my lord.
Now, my
there
lord,
is
they are
no
counting the-
No, my lord. There is no, in this letter, my lord will see, there is nowhere mentioned that he has been released on bail.
Malad, enclose the bail application also, Malad. If
Nowhere. His intimation itself nowhere speaks about that I was arrested and I was released on bail.
Malad, it is sufficient to Malad constitute.
No. There is no mention.
Malad,
No mention.
No mention.
No mention.
Malad, relevant grievances is under Malad. That's as mentioned ground that I have been suspended from my job 14 May.
No, there is no mention. I have read.
Malad.
Absolutely no mention that you have been released on bail.
Malad, Of course, my lord, that is, my lord.
Now, that was dealt with in the next page, a representation dated so and so.
My lord.
That was dealt with, but there is no mention
No mention.
that you have been released.
My lord, I have enclosed, my lord, may kindly peruse that my,
There is no enclosure of the bail order. Since you have appeared, we'll put you on notice, returnable on next Wednesday, you get the records.
Yes, ma'am.
that's,
But this is a matter to be examined,
yes, my lord.
Yes, ma'am.
but in my tentative view, it is tilted against the state still. It is no order. If it is not communicated, if something is in the file, Bachitra Singh says, right from Bachitra Singh, that it has no value at all, unless it is communicated.
My lord,
Passed, issued in the form of an order in conformity with Article 162 in the name of the governor. It has
But-
no value in the IR law.
my lord, I would,
Exactly, that was,
Bachitra Singh is followed.
my lord,
Right?
exactly, that was my submission before, Anwar single bench, my lord. Just notice, my lord.
Lennox. Additional additional advocate
Advocate General.
Honorable Police for the appellants and Mr. So Leonard himself, who has entered appearance
Okay.
on behalf of the
Short response, my lord.
sole respondent, full stop. In this intercourt appeal, a judgment, an order passed by land a single judge. A judgment order dated 21/11/2025, passed by land a single judge, issued WBC number 195/2025, has been assailed. Full stop. The sole respondent was placed under team suspension with effect from his date of detention, that is 14/5/2024, by an order dated 2/6/2024. Full stop. It is permitted, it is stated that the respondent was released on bail on 18/1/2025.
Madam.
Full stop. As per sub-rule 6, read with the first proviso to sub-rule 10 of Rule 10 of the Central Civil Services. Classification, control and appeal, bracket close, rules 1965, in case of deemed suspension, the period of 90 days for review is to be computed from the date the government servant detained is in custody, is released from detention, or the date on which the fact of his release from detention is intimated to his appointing authority, whichever is later. Full stop. It is the case of the appellants that the intimation was on 4/3/2025, and the review meeting was held on
29/5/2010.
29/5/2025. Full stop. Thereafter, the order extending the period of suspension was issued on 3/6/2025. Full stop. On the other hand, the contention of the respondent is that it is the order issued for extending the period of suspension is material in terms of the aforementioned rules. And if the period of 90 days is to be counted from 4/3/2025, then the order issued on 3/6/2025 was beyond 90 days, full stop, the date of holding the review meeting is of no consequence unless an order is issued in conformity with Article 162 of the Constitution of India in the name of the governor. Full stop. The matter request consideration. Full stop. As the sole respondent has appeared, comma, let notice be issued. Full stop. As agreed to by the Learned Council for the parties, the notice is made returnable on 4 December 2025. Mr. So-and-so, Learned Council, Learned Edition Annexer to Mr. So-and-so by today. By today. First off, the state shall also produce the relevant records regarding the suspension, relevant records related to the suspension of the sole respondent on the returnable date. First off, till next date, the status quo as obtaining today shall be maintained by the parties. Full stop. It is observed that an endeavor will be made to dispose of the redepil on the returnable date.
Obliged, madam.
Line of decisions from Bositar Singh is against you.
Malad, the next date I'll try to. Malad,
Item number 2,
2 to 5, my lord.
2 to 5.
All these IS for condonation of 41 days delay.
Heard Mr. So Learned Additional AG, but you're appearing here.
Yes, madam. It's Malad,
Any objection?
no, madam. Malad, this is the Malad. May I take, may I pray, Malad, I'll take instruction from the department.
This is,
It's 41
he's a
days of delay,
performer respondent.
You're performer response.
Yes, madam.
Yes, my lord. In fact,
Oh,
he,
official respondents are there.
yes, my private respondents are
So
there.
you're official respondents.
Correct, madam.
Okay, then we have to issue notice.
Yeah.
Okay, heard Mr. So-and-so Learned Additional AG. Oh, you're appearing.
My lord, I have instructions to appear on behalf of the private respondents, my lord, in item number 2, 3, and 5, my lord.
Instruction to condone the delay also.
My lord, it may be about 30 days delay. I have not received the copy of the condonation petition.
1 days.
41 days.
My lord, that may be condoned. Up to lordship, my lord.
Okay, good enough.
Yes, my lord.
So we'll fix a date for admission. You come on that
My
date.
lord, my lord, my lord.
Tell
my
your
lord.
convenient date.
My lord, next 2 weeks, most probably, the bench may not like to take up the matter, my lord. This,
Okay.
The judgment is passed by Justice Silo. After that, my lord.
Okay. When? 22nd? Oh,
my
sorry.
lord, could it be
15? 15?
15th or could it
15.
15?
my lord? 19th or 17th, my lord. 19th or 17th, my lord.
17, 17.
17.
My lord, my lord. My lord.
Okay, I can record your name for the
Private respondent.
writ petitioner
Yes, my lord.
and private respondent, all the private respondents.
Yes, my lord, in items 2, 3, and 5, my lord. Mr. Parme is in item 4, most probably.
You are appearing in which
2,
item?
3, and 5.
2,
my lord.
3, and 5.
3 and 5. Who is appearing? Otherwise, you have to issue notice making it returnable on the same date.
My lord.
Yes, my lord.
4. Item number 4.
Item number 4, Mr. Perme, my lord, item 4 only, there is only one petitioner. One respondent, private respondent.
Okay.
That,
Will you have to issue notice?
Yes, that we can issue notice.
Hard.
The rest, the delay can be
Uh,
done.
Pencil and it. Additional, yes, we can follow.
Additional, yes.
For 3 item.
Yes. 1, 2, and 4.
Right, additional advocate general, Arunachal Pradesh for the appellants. Mr. P.D. Nair, who has appeared through virtual mode for the applicants for the opposite party.
In 1 to
1
59.
to
59.
59,
Mr. Kato for 60 to
From
60.
60 to 63, my lord.
Mr. Kako, learned counsel for the learned DYSGY
My lord.
for the opposite party number 60 to
63.
63. Full stop. On the instant interlocutory application under Section 5 of the Limitation Act 1963 is preferred for condoning the delay of 41 days. Condoning delay of 41 days in filing the accompanying writ appeal against
Judgment and order dated.
judgment and order dated 17/9/2025 passed in a writ petition, WPC number 294 within bracket AP stroke 2024. So we have gone through the statement and averments made in the instant application, explaining the delay of 21 days. Full stop. The learned counsel for appearing for the opposite parties have submitted that since the period of delay is 41 days, such period delay can be condoned in order to file the accompanying writ appeal on merits. Full stop. In such view of the matter, in view of the above submission made by the learned counsel for the parties and having regard to the explanation provided regarding a period delay, the instant application is allowed. Full stop. As sought for by the learned counsel for the parties, the accompanying writ appeal, after registration, is to be listed on 17/12/2025.
Madam.
This is 2. Then 3 appellants. Then Mr. Nair is appearing for opposite party number.
One and
Tell
two.
me.
1 and 2.
1 and 2. And Mr. DYSGY
For respondent number 3, 4, 5, and 6, madam.
5 and 6. Period is
41 days. Writ
You write-
petition number will be 174.
174. Then item 5.
Item 5.
I prefer 1 to 90.
1 to 90.
I put it in the item number 1.
That will be 1 to 90. Item 5.
Item 5.
Private
PD Nair 1 to
90.
19.
90.
90. And DYSGY 91 to
94.
and WPC number
WPC number will be
50, madam.
193 of 2022.
Okay, this is item 5.
Item
Okay, 4. Don't write the name of Nair. So and so for the applicants and DYSGY for the opposite party number.
2 to 5.
The instant interlocutory application under Section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 41 days in filing the accompanying writ appeal against the judgment and order dated so and so. Same. Passed by the learned single judge in a writ petition, WBC number. You check the WBC number. As Mr. So and so, learned DYSGY has appeared and accepted notice or issued notice returnable on 17/12/2025.
Madam.
As DYSGY has appeared and accepted notice on behalf of the opposite party number so and so, issuance of formal notice to the said respondents, opposite parties are dispensed with. Is dispensed with. Post of the applicants shall take steps for service of notice upon the opposite party number
1.
1 by a speed post within 2 working days from today. List the case on 17/12/2025.
Obliged, madam.
But copies of the writ appeal may be.
Yes. Copies of the writ appeal will be.
Writ appeal. Okay.
I'll furnish.
আগতো order কেইটা 235 লিখি দিব Mr. So and additional AG shall in the meantime also furnish a copy of the requisite number or how many copies? 59 is not required, 90 not required. How many? Tell me. 2,
My lord,
3,
3 copies, my lord.
3 copies.
Copies each, my lord.
Wherever there is more than 1 respondents,
My
3 copies.
3 copies.
Wherever there is 1, 2.
No, no.
So requisite number of extra copies of the requisite number of copies of the memo of appeal along with annexer to the respective opposite parties within 1 week from today.
Yes, madam.
Within 1 week from today.
Mine.
So understanding is that
Yes, yes.
3 copies in case of numerous respondents,
Mine.
2 copies in case of lesser respondents.
Yes, madam.
Deeply obliged, my lord.
Please, Lordship. Lordship, I beg to mention item number 3 and 4.
Okay.
Lordship, the conducting council is Guwahati based, and due to some personal problem, he could not come today, Lordship.
Mr. Yukenas or HK Das?
HK Das, Lordship.
Okay. On the prayer of Miss
K. Basar.
K. Basar,
Yes, Lordship.
Learned Counsel for the petitioners.
Lordship, matter may be.
You have informed other side.
Yes, Lordship. SCRD.
Okay.
Taken
With the consent of the Learned Counsel for the respondents. Kama has made a prayer for adjournment of cases by for
List after 3 weeks, Lordship.
3 weeks. You are a respondent.
Yes, Your Lordship.
With the consent proposed, it is the prayer is made with the consent of Mr.
M. Taso.
Learned Counsel for the respondents. List the cases accordingly after 3 weeks.
Obliged, Lordship.
Yes, madam.
Your Lordship, I would like to mention item number 8.
8.
Yes,
Yes.
the main council is out of station
Okay.
today.
Who is the main counsel?
M. Bagra.
Okay. A prayer for adjournment is made on behalf of the petitioner by Ms.
R. Takam.
Learned Counsel. Also, as the prayer is made with the consent of the learned state respondents.
And your Lordship, can the
Comma,
date be
list
fixed?
the case after
Date, any particular date? December 5.
December 5.
Yes.
Okay. 5/12/2025 as prayed for and agreed to by the learned counsel for the parties. Yes.
Much obliged.
May I, Your Lordship? Your Honor, I would like to mention item number 6 on behalf of the Learned Counsel T. Game. Your Honor,
Learned counsel for the government.
Your Honor, no, I'm the petitioner.
Okay.
Your Honor, the Learned Counsel is out of station. I have taken the consent of the respondent counsel.
Okay, Miss Learned Counsel appearing for the petitioner has made a prayer for adjournment with the consent of the Learned Counsel for the state respondents. Full stop.
My Lord,
Has prayed for release the case after
2 weeks of time maybe.
2 weeks on a date to be fixed by the office.
I may please, Your Lordship. Lordship, I beg to mention a pending matter, WPC number 04/2025, to be listed on 7th of January 2026. Since the Learned Counsel will be coming from Guwahati, so we want a particular date for this matter. Hence, the matter may be fixed on 7th of
Okay.
January 2026.
Hello.
Deeply obliged.
7th of December is Sunday.
7th of January
January.
2026.
Okay.
Item number 1.
May I
Yes,
please,
madam.
Your Lordship. My Lord, the matter is regarding appointment of assistant public prosecutors. Yes. My Lord, the practice here has been, they have a list of panel advocates which are appointed in consultation with the,
Sailing the selection selectively,
yes.
not making all the new assistant public prosecutors.
Lordship,
Please.
we are practicing, sorry, we are selecting, sorry, we are
Did you
challenging on,
apply? Did you also apply?
yes,
You applied.
yes,
And then thereafter you are challenging it.
yes, my Lord, because,
Then once you have applied, then you are challenging it, we should notice.
my Lord,
Once you have.
yes, my Lord, I get,
Right.
yes,
Then thereafter,
yes,
when you have found yourself unsuccessful
Lordship,
Then
there was no,
challenge.
there was
And
no,
no selection process criteria has been.
no, the criteria they have said is that we will look into the cases taken up. Now, what would be the cases taken up? The cases taken up,
Well, you should notice once you have participated,
Lordship.
and thereafter, when you were unsuccessful, now we have mounted the challenge.
Lordship, there was no selection process. They simply
Whatever
asked us
you
to
have
submit
participated.
documents, Lordship.
You
And
waited for the notification to be published.
there is also another aspect of the
The
matter
expectation that your name might be there.
that is there, of
You
course,
should
Lordship.
Right.
But Lordship, there is one thing I would like to apprise.
What more you are expecting?
Yes.
Nothing.
Yes, my lord.
No, nothing can be expected.
No, my lord. Let's just hear me just for a minute, Lordship. In the panel list, that was supposed to subsist till 2027, Lordship.
You are not out of the panel.
No, I am as good as out because we were asked to submit all our return all the files.
That
So
is in
basically,
conformity because as per the BNSS
yes,
or
yes,
earlier CRPC,
yes,
the criminal trials are to be conducted on behalf of the state
yes,
by the assistant public prosecutor.
yes,
So this is in conformity to the provisions.
Lordship.
Earlier, what was followed was not in conformity with CRPC. or-
We were also appointed by the Home Department,
Right, Home Department, but
Yes.
you are not assistant public prosecutor.
Lordship. There is there, of course, Lordship.
So what does CRPC or BNSS says? CRPC is available
In case of
or
public
BNSS.
prosecutors or section 18 and 19 of the
So-
BNSS.
Or what does it say?
Section 18,
18, no.
section
All-
18 is regarding appointment of public prosecutors in which that should be in consultation with the session judge in
And
case
who
there
will
is
conduct the prosecution?
the public prosecutors. The assistant public prosecutors, they are appointed by the government, of course.
Huh. So
Section 19.
assistant public prosecutor, say earlier, almost similar. Okay, BNSS,
Almost similar, Lordship.
almost similar. I am more conversant with CRPC.
Yes.
I still do not remember what are the
It's,
BNSS.
if I may say so, it's exactly the same.
Hmm.
There is no
Which is
difference
the
at all.
provision?
Section
Public
18 is public prosecutor. Section
Prosecutor.
19 is assistant public prosecutor. We're concerned with section 19. Because there is,
Section 19.
yes, there are no public prosecutors at the moment.
Section 19. 19, assistant.
Yes.
And they are to conduct the prosecution for the state as per the provisions of BNSS.
The public prosecutors and the assistant.
Because, say, 19(1)
Yes.
shall appoint
Mm.
in every district one or more assistant public prosecutor for conducting the prosecution in the court of magistrates.
Yes.
And additional public prosecutor and public prosecutor for the court of district judge and additional session judge, etc. So taking of the business is according to the provisions of BNSS 19(1) only. And moreover, you have participated. As you should have laid the challenge as soon as it was published. But so we'll issue notice.
Okay.
Why selectively 3 persons have been?
No, because we're concerned with the district of Papumpare here. But other candidates, they are from other districts.
Land Council for the petitioners.
May I pray, my lord, that a short date may be given.
Sorted, you have to serve these 3.
Lordship may kindly allow us to do by justice service. They are here only.
Okay. Lawyer versus lawyer.
Yes, Lord.
Huh? Okay.
Many.
Miss so land government advocate for the respondent number 1 to 4. Post of the petitioners were appointed as panel advocates by orders dated 7/3/2025 and 8/4/2025 for conducting cases before the courts of judicial magistrate first class, chief judicial magistrate, additional district and session judge, and district and session judge, page 20, in Papumpare district, right? These petitions are from
Yes,
Papumpare,
Papumpare.
with a tenure with effect from 1/1/2025 to 31/12/2027. Post-hoc. While the petitioners are continuing, a circular was issued on 10/6/2025 inviting applications for appointment as assistant public prosecutors, on temporary basis under section 19 within bracket 1 of the Bharatiya Nagorik Suraksha Sanhita 2023 in respect of Papumpare district. Post-hoc. The petitioners submitted their applications in response to the circular dated 10/6/2025. Post-hoc. According to the petitioners, the respondent authorities had adopted arbitrary, had adopted irrational criteria and in an arbitrary manner, adopting pick and choose policy, published a list of assistant public prosecutor on
15 October 25.
15 October 2025. Appointing 25 number of advocates as assistant public prosecutor in total, including how many in Papumpare?
4, Lordship, but we are
Including
challenging only
4.
3.
In Papumpare district.
Yes.
Post-hoc. Subsequent to the order dated 15/10/2025, an order was passed on 29/10/2025, whereby the panel advocates, like the petitioners, have been who are handling criminal cases in Papumpare district or all over.
This is for Papumpare district.
Papumpare?
No, Lordship, all panel
Have been
advocates, sorry.
directed to hand over all the case records they were handling earlier, to the newly appointed assistant public prosecutors. Post-hoc. Agreed by such developments, the petitioners are before this court. Post-hoc. The Ms. So-and-so Learned Counsel for the petitioners has submitted that the respondent number 6 to 8 have been appointed as public prosecutor,
Assistant public prosecutor.
assistant public prosecutor, despite having much lesser experience than the petitioners. Right?
Yeah.
Is your case?
Yes.
Okay. Issue notice before holiday.
Yes, Lordship.
Issue notice
As soon as possible, Lordship, because the appointment is only for 11 months.
2025. As Ms. So-and-so has appeared and accepted notice on behalf of the respondent number 1 to 4. 1 to 5.
Yes.
1 to 5. Issuance of formal notice to the said respondents is dispensed with. However, Ms. So-and-so, Learned Counsel for the petition, shall furnish requisite number of extra copies of the writ petition to so-and-so within 2 working days from today. The petitioners shall take steps for service of notice upon the respondent number 6 to 8 by speed post within 2 working days from today. Post-hoc. In addition, as paid for, the petitioners are permitted to take steps for service of notice upon the respondent number 628 by way of Dusty also, which is to be routed to the registry of this court, post of the learned, the petitioners. After service of notice upon the respondent number 628 by way of Dusty shall file a compliance affidavit to that effect before the returnable date. To establish the case on 19, oh, sorry, 1912.
Obliged.
Item number 2.
Yes, sir.
Mayor Lordship, the petitioner have been aggrieved by the land compensation award,
Land compensation
land compensation
amount.
award. Yes, Lordship.
Hmm.
Against their land.
Award has been passed.
Yes, award have been passed.
You are
Lordship.
satisfied.
Yes, Lordship, the case is that the petitioner herein have an ancestral land which was,
It is not acquired. It is right of way.
yes. Lordship, initially,
So Electricity Act and Telegraph Act will come into picture.
yes, Lordship,
Hmm.
for construction of 132 kV
Hmm.
power grid.
So there is a provision otherwise to
Lordship,
make application before the principal court of original
Yes.
civil jurisdiction.
Lordship, actually, physical verification.
So as on that,
of the
we will
land-
issue notice.
Lordship,
If we find that matter is to be decided by principal court of civil jurisdiction under 10(6),
Yes, my lord.
we will forward it.
In fact, he should have directly approached instead of keeping this matter pending under the Electricity Act.
We'll record your submission and what
Lordship, even under
Telegraph Act. Do you have the Telegraph Act?
Telegraph Act.
Indian Telegraph Act, 1885, perhaps. What is the provision? 10(5) or 10(6)?
10.3. I believe 10.3 was.
Have you read Telegraph Act and Electricity Act?
It will not come under the Lara Act.
Not Lara Act. That 2013 Act.
This is
It will
a-
not come.
Power grid.
Power grids, right of way,
Lordship.
right? It is Indian Telegraph Act, 1885, read with Electricity Act, 2003. The provision should come there. If you are unsatisfied, then
Lordship,
you have to make an application
Uh-huh.
before the district judge. Anyway, we are issuing notice.
Lordship,
You examine.
Lordship, till then, in
What
interim
till
order,
then?
interim order maybe.
What interim?
Because if the trees and forest are clear, there I have no case then. So till then only two pillar is there.
Two pillars.
Yes.
85%.
My petitioners have only two pillars. That can be in the meantime that can be stayed.
What
Pillar.
say?
Clearance of forest.
Public interest.
First of all,
My-
whether
Lord-
this
Lordship,
petition
Give way to
is
public interest.
Lordship, I have no intention to hold
Okay.
the public importance.
We
But
can-
actually,
we
Lordship-
will say that the responding authorities shall ensure that proper survey is made in respect of the petitioner's land and keep and maintain the records for
Lord-
further consideration.
Lordship, the cases, the survey have been
Well,
done in my presence, Lordship.
if such orders are passed, my lord, they will take it as an tool to stop the entire project. Otherwise, they will create a law and order problem.
Yes.
Yes, Lordship.
Let me see first 10.
Lordship, initially, my Lordship,
Why don't you file an application under section 10(3)?
I have filed an application under section 64 of LAR.
Oh, then not maintainable.
Not maintainable.
Not maintainable. I'll dismiss. Section 10(3) of the Indian Telegraph Act.
In my representation, there is clearly it is not mentioned, but
The
In your
protest
legal-
representation was
You are-
filed before the
Did a representation before a wrong authority.
Lordship.
Legal, in the legal notice also, he has mentioned only section 64 of the LARA.
Heard Mr. Swainshall Learned Counsel for the petitioner.
Lordship, I may be,
Petitioners.
Lordship,
And Mr. Swainshall Learned Additional Advocate General, Arunachal Pradesh, for all the respondents. Or for respondent number 1 to 6.
1 to 6.
1 to 6. Right. Full stop. The case of the petitioner is that for the purpose of stringing the transmission line and to get the right of way for 132 kV Khupi Bomdila transmission line, comma, the respondent authorities assessed the compensation estimate as regards the right of way sought to be acquired in respect to the petitioner's parcel of land wherein
serial number 17 and 20, Lordship. My name,
wherein which tower, sir?
Lordship.
Which tower?
Tower,
Wherein
tower 11,
tower
tower 11.
number AP stroke 11B and AP 12A
Yes, Lordship.
are to be located. First stop. As per the authorities had initially assessed the compensation amount at, yes,
28 November 2024.
what is the amount?
Amount is, Lordship, 1 crore
Hmm?
19 lakhs 99,000.
Where is that?
That is, Lordship, it's page number
24.
Your
20.
name, sir? Prem Khandu.
Page number 24,
Prem Khandu and Gishum Khandu. Page number
24, serial,
24.
serial number 17.
Serial number 17. Prem Khandu. And where is petition number 2?
Next page, Lordship, next page 25.
AP 11B and AP 1112 question.
Yes.
Already? Estimated at rupees 1 crore 19 lakh 999 and 1 crore 79 lakh.
98,200. 98,200, Lordship.
1 crore 93 lakh 69,400 respectively. Post op. But a decision was subsequently taken for reassessment of the compensation amounts for the right of way by the respondent authorities by constituting a board consisting of 5 persons and according to the petitioners, comma, the substitute, the board so constituted, comma, have reassessed the compensation amounts at a much lower figures, full stop. Aggrieved thereby, the petitioners are before this court, full stop. Mr. Swainshall and additional AG, Advocate General Arunachal Pradesh has submitted that the right of way are have been sought to be acquired under the provisions of the Indian Telegraph Act 1885, read with the Electricity Act 2003. Full stop. In such view of the matter, if the petitioners are aggrieved by assessment of lower compensation amount, the petitioners should have approached the
The district.
By invoking approach the appropriate forum by invoking the provisions of section 10 within bracket 3 of the Indian Telegraph Act 1885.
Section 16.3, my lord, I think.
Oh, I'm sorry. 16.3.
Lordship, at least my representation may be
Full stop.
considered.
Already assessment has been done.
Lordship,
So
that,
that record is available.
Lordship, that
That
assess-
record will be kept.
Yes, yes.
The respondent authority shall ensure that earlier
Record,
assessment proceeding, records of earlier assessment proceeding should be kept.
yes.
If you are entitled, you'll be getting that 1 crore.
Lordship,
And if you are not entitled,
that
don't get them.
Lordship,
Why should we stop?
Lordship,
Subject to bank
Only-
guarantee.
only limited player, Lordship, my,
Deposit of
Otherwise-
50 lakh each.
Otherwise,
My
this
representation
assessment,
will
if
be-
my lord will say,
Returnable in 4 weeks. As Mr. So-and-so has appeared accepted, notice 1 to 6, this formal notice dispensed with extra copies within 2 working days. The petitioner shall take steps for service of notice on the respondent number 7 by speed post within 2 working days from today. Post of having regard to the projections made on behalf of the petitioners, the respondent authorities shall ensure that the records pertaining to earlier assessment proceedings, wherein the compensation amount for the petitioners were assessed at rupees 1 crore and so, those 2 figures are maintained for
as well as the subsequent,
as well as the subsequent proceedings which resulted in assessment of lower compensation amounts. And ensure to maintain. Both will be there. So first
Lordship,
proceeding is
that-
correct.
Yes.
We are not stopping it.
yes,
Or
Lord.
shall we observe?
Lordship.
oblige.
Deeply obliged.
Don't stall public project. If records are there,
Lordship,
you are entitled for the first figure,
I am not,
1 crore, 80 lakh, 1 crore, so and so. You'll get it.
there is no, my intention to hold the national project,
So
but I have been.
you'll get it if you are really entitled.
Lordship, deeply obliged.
But you should have approached the district judge.
That,
The question of maintainability of the repetition is kept open for consideration on the
my only case is that Lordship, reassessment was done with, behind my back,
in
Lordship.
principal state, I would have dismissed it limine, but I am not dismissing it Arunachal Pradesh.
Deeply obliged.
Item number 5.
If it is in a principal state, I would have dismissed it in limine. Would not have entertained. Madam, yes.
I may please, Your Lordship. Lordship, by filing this particular writ petition, the petitioner
Madam,
is
for
challenging.
hearing, I am not today for hearing. To be fair enough, I have to attend a urgent official assignment. Someday else. Any day, madam. That one, DC, passing an order.
Yes, Your
But
Lordship.
I would have entertained, but I have no time, I have to leave.
December. Can it be fixed on 8 December, madam?
Sure. Now, please note the names for the parties. As
Election
sought
have-
and agreed to by the learned council for the parties, release the case on 8/12/2020.
It's the election act.
Please take down the names. 8/12.
Wait कर लेते हैं। क्या? ऐसे है।
18 वाला वो line.
Okay, madam?
Your Lordship, if it may be fixed just on the next week, because I will not be available on the
15,
8th week. 15.
15, 12?
15 election, my lord. We have panchayat election.
Tell me.
16, my lord.
16?
16 is fine.
Otherwise 17, my lord. We might go to cast vote, my lord.
Okay.
17.
17 is fine.
Sorry. Because
Give
I
your
have
pleasure.
to be there, all the judges and chief ministers there. I think I am one of the members.
Your Lordship, there is an interim order that may be
The interim order fast track shall continue till the next day.
deeply obliged.
My lord, one more thing, my lord, getting the interim order, he's constructing the house now. This is
I would have disposed of the petition, but because of constraint of time, I checked it. It appears primarily he assumed jurisdiction of the civil court.
The ADC.
Looks like.
Yes, Your Lordship.
Item number 7.
Seven. Nobody is present,
Yes, Your
so we
Lordship.
defer.
Yes, Your Lordship.
According to it is already infractious.
Yes, Your Lordship.
Since nobody is there, Mr. Kambuk is not there.
Yes, Your Lordship.
There is no representation on behalf of the petitioner. Today, petitioners check, to one or petitioners today on call. Post of as per office note dated 27/11/2025, the petitioners have not yet taken steps for service of notice upon their private respondents. Post of Ms. Soenful and government advocate for the state respondents is in attendance. Post of in view of and has submitted that the subject matter of the petition may perhaps be infractious. Also, in any view of the matter, as there is no representation, as there is no representation on behalf of the petition student call, let the case come up for answer justice be listed again after a week on a date to be fixed by the office.
Obliged, Your Lordship.
Yes, Happy New Year to you all. Happy Christmas. So I'll be coming in the next year only.